So let's set the stage here with the assets that we're even referring to, right? Because
Yeah.
if you have, so what doesn't pass through probate, and correct me if I'm wrong here, but I got beneficiary designations, right? If it's on life insurance or your retirement account, that stuff won't pass. If it's, do they say it's by law when it's titled like joint tenants with right to survivorship or payable on death, or is that considered by law? But the titling, right? The titling.
Yeah. I don't know if it's by operation of law or something else, but yeah,
Okay.
if you've got the titling matters.
Okay, and then trust, if it's in a trust, it doesn't go through probate, right?
Right.
So am I missing something? Those three areas, like you can, those assets will avoid probate entirely. Now, what doesn't is a will. Am I correct there?
Yes, that's correct.
Okay. Okay, so then so the assets that might go through probate, we're talking most commonly it's like real estate, financial accounts, stuff like that, right?
Yeah, so it's Hawaii. We're talking national versus Hawaii probate. I'm really not that, going back to your intro, I'm not really that versed on how probates happen in, nationally or in other
Mhm.
states. I have had sort of experiences with people from other states. Most recently, I had someone from South Carolina, so I learned a little bit about South Carolina probates, and it's wildly different. And
Okay.
California, even I do hear a lot, learn a lot about California probate proceedings because there are a lot of folks who have connections with both Hawaii and California.
Mm.
But for Hawaii, if there is real estate owned by one individual or, only an individual name. So you could have joint tenants, you could have a husband and wife or spouses, parent and child, what have you. Joint tenants or tenants by the entirety for married folks and the last person standing is passing away, we're going to have to do a probate. If it's just an individual who owned real estate in their own name, we're going to have to do probate. If it's tenants in common, so people don't always know whether they own property with another person as a joint tenant or as a tenant in common. If you're a tenant in common, then and let's say there's two people, 50-50 tenants in common. One of those owners passes away, you have to do a probate for their half.
Mm.
Um, so that, or for Hawaii, if it's a Hawaii-based financial institution. So that gets tricky too when I have people with Bank of America accounts,
Mm.
Wells Fargo, Citibank, some of these high yield savings accounts with national banks or mainland financial institutions. They're not subject to the same threshold as a Hawaii financial institution. So the local credit unions, the local banks. If there's an account, if you in the aggregate, so if you add up, someone has four accounts and you add those four accounts together and they're over $100,000, then you have to do probate to get at any of those accounts. So
Mm.
if you do have Hawaii accounts, like mom or dad had 20,000 at the credit union, between savings and checking. They didn't have a beneficiary. It's they're the only ones on the account and then they pass away. Hawaii does have a process for getting that without probate,
Okay.
if that's the only asset. But so back to like the benefit, what doesn't cause probate? If it is small and if it is local, it doesn't always need a probate either. But real estate that's in someone's individual name, or if the accounts add up to over 100,000, that will cause probate. The common ones I see, even when people have really well laid out estate plans and they funded their trust with most of their accounts, is sometimes these stocks. And it might not even be that much. And it's like individually owned stocks,
Mm.
not investment accounts, but they every now and then it's Hawaiian Electric stock. I don't know why.
Right.
That maybe they inherited from the parent, the grandparent, and now they just haven't. It's maybe not even worth that much,
Mhm.
but they never got it out of their name. So it's something
Right.
that they own individually outside that will cause a probate.
Yeah, that is common. And I think it's a old school mentality, not in a bad way, but there was like when they got these shares of stock years and years ago, decades ago, and it's not a bad thing if you don't like sort of cash them out, diversify, and put them into a financial institution,
Right.
but it does cause some interesting, like you said, some interesting uh processes once it needs to pass on, right?
Yeah, because you can change the ownership of the stock to a
Mhm.
trust, or you can designate a beneficiary a lot of times. Once you're doing that, you're really sometimes changing other things about the ownership, but there are ways to deal with it during lifetime to avoid probate, but that's the one that just seems to be left out every now and then.
Gotcha. And then so you're mentioning other states there. So if I need to go through probate and 90% of my assets are in Hawaii, but I have 10% of my assets in California or Washington, I'm still going through I don't need to deal with the other states' probate process, right? I'm still just focused on Hawaii.
If there's a probate required, and like let's say, so for you in your example, this person did no planning, they got 90% of everything here, but they do have some stuff in another state. You do a primary probate proceeding here in Hawaii, and
Hmm.
then you have to do, it's called an ancillary proceeding. So you do have to do sort of a, I just, when I'm talking with clients, I'm like, you do a piggyback proceeding. Like it's not a full-blown probate always. Like you're not having two separate, because especially if there's a will, we'll talk
Hmm.
about will versus no will, but if there's documents, they're only going to get filed at one of the courts, and then the originals, and then the, copies will be presented elsewhere. But you can't just that's so if you have something in Washington and California, you're going to have the Hawaii probate, you're going to have a Washington piggyback proceeding, you're going to have a California
Hmm.
piggyback proceeding.
Interesting. Yeah. So I guess it can get pretty cumbersome and complicated the more, I guess, assets you have in other states.
Yeah, once people talk about that, it's like, okay, we should do some trust planning because you don't
Gotcha.
want to have to do
Right.
the waiting game there will just add time because the first state's got to get that you can't have those all running concurrently, to get things started because the
Hmm.
piggyback ones need the documents from the original proceeding. So I have I have the opposite that will come up. Someone lives on the mainland and then owns property here and they're doing a probate in another state and they're needing to deal with the Hawaii asset. So I'm tasked with doing the Hawaii piggyback proceeding to
Gotcha.
California, or I have one now for Virginia that we're working on. So it's the states will talk to each other in that way, but they do need separate proceedings.
Okay. Okay, since we're on the topic of like when probate is required versus avoidable with, the trust and the titling of documents, beneficiaries, out-of-state assets, I think we'll talk about the will, right? Because I'm sure some people might think, well, I have a will, I don't need to go through probate, right? So if you want to, I know that's probably a big conversation to have about how the will plays in the probate, but you want to give us some background on that?
Yeah, well, it's not even that big of a thing. You either have a will or you don't. And if you only have a will, it has to go through probate before it can do anything. So you have a will that says, when I pass away, I want everything to go equally to my kids, and I want my oldest child to be in charge. Great. Your oldest child cannot take your will to the bank and say,
Right.
here's mom's will, and can I have her accounts now, please? It has to go through the court has to issue a document, and it's the court document that says, so and so has been appointed as the personal representative. I'm going to throw out those terms. So
Yeah.
executor is commonly used, but Hawaii law calls it a personal representative, but same,
Hmm.
as far as responsibilities and thinking of who we're talking about. So the person in charge, the personal representative, has been appointed in this state and has full powers to, deal with estate assets. So the bank wants to see that document. They don't ever want to even see the will. They don't want to see that the will says it's an equal split or who the beneficiaries are. They don't care. They
Hmm.
just want to know who they're allowed to deal with and sign the paperwork to close the account, or who they, if that person tells them, make the check out to me, the bank says, okay, great. They're relying on what that person is telling them once they are court appointed. So the will, a lot of people, that's, I would say, the biggest misconception is that a will is going to do you just fine.
Hmm.
Um, the will help because you can designate, who's going to be in charge. You avoid that fight maybe with your kids if there's competing people wanting to
Mhm.
serve as the personal representative, but you don't avoid the court proceeding with a will.
Gotcha. Um, Interesting. So before we move into like the probate process and the kind of
Hmm.
the mechanics, and we'll kind of revisit informal and formal and the will and all that. I was just curious, since we're talking about assets that avoid probate or are required in probate, the transfer on death titling of a home.
Hmm.
Um, so if you could talk about that versus titling a home to a trust versus a probate and a will, because I think not too many. It's probably, I don't know. You could tell me, is the transfer on death titling probably the least common of the three, the trust or the probate?
Yeah, yeah, I would say so. I would say the transfer on death deed is not that common because it's people don't really know about it. But the way that a transfer on death deed works for real estate is similar to the way it would work for a beneficiary designation on any other kind of asset account. Um, the when there are folks who maybe don't want to spend the money, they're less expensive than a trust. So when there are folks who maybe don't want to set up a trust and they're saying, like the only thing I'm worried about is my house,
Mm.
um, we can do a transfer on death deed. The limitations of a transfer on death deed versus a trust are like your transfer on death deed can say, I'm leaving it to two people. I want like two kids.
Mm.
And you cannot say, and if, child A has passed away, I want their share to go to their kids. You can't do that sort of planning. The transfer on death deed names beneficiaries, one or more, and if any of the beneficiaries have passed away, it just goes to the others. So it's sort
Okay.
of last man standing on the beneficiary transfer on death deed. Um, and sometimes that's okay. Like I have done it for clients where, maybe there's a parent and a child, and it's like, I'm just worried about getting the property to my child. If my child doesn't survive me, and that means there's no surviving beneficiary of this deed, and it ends up in probate, and our more distant relatives are going to get it, that's fine. I'm
Mhm.
not that let that be then, because
Right.
my primary goal is just taking, if my kid survives me, I want them to have it. And so, that's okay in that situation. The trust can deal with the contingencies, the what ifs. We can deal with you've got two kids. If one passes, you want to benefit their children, your grandchildren, or you've got four kids and you only want to leave it to the three because you gave money to your fourth child to buy a house or something. I mean, there's all of those
Sure.
different, we did this, we did that, we want to make it, as the more specific and detailed you want to get, the more strings attached you want to do, you can do that in a trust. And I think that I think I mentioned this in the last show I did with you, but I think it's a missed opportunity for Hawaii homes where you've got unique family situations. You got
Mm.
multi-generational living, in a home, multiple generations living in a home. The older generation is the owner. If they're going to pass away, you've got the child who's been living there, taking care of the parents, helping, putting money in maybe. And then you've got the other ones who have their own properties or have moved away for whatever reason. And maybe you want to address the uniqueness of that situation in a certain way. You can. There's ways where the home itself can have rules in a trust about what are we going to do with this property after the parents are gone, or the owners are
Yeah.
gone. So the trust is way more expansive in that sense. If you don't do anything and you pass away and the property is something that needs a probate proceeding before we can change title to the new owners, that I think we're going to talk about too. The law in that case, if there's no will, if there's a will that says my house goes to XYZ, the will goes through probate, the personal representative gets appointed, they can sign a deed to XYZ, assuming there's no other issues. Um, but if you don't have anything, the law will say, okay, based on this person and who has survived this person, who are the beneficiaries? And it's not always what people think, or
Right.
sometimes crazy situations come up. Um, yeah, so that's kind of the biggest bird's eye view of the difference. And I'm probably my bias is probably coming through with I think the trust is great,
Sure.
but yeah,
I agree, and I think for those listening who might think, because I'm a big advocate of simplicity, simplicity in finances, in
yeah.
in investments, and simple often works. But I think it sounds like the downside to the transfer on death, one, there is simplicity, but you can't answer all those what ifs, right? And it's
Hmm.
one thing to say, well, it's just fine, it's just going to be simple. But I would say for anybody listening, maybe take that time and say, well, let me speak to somebody like you and see what kind of questions we could answer through titling it through a trust versus the transfer on death, right?
Yeah, and I did recently have a situation come up where I did a transfer on death deed with um there was a mother and son on title, and they both signed a transfer on death deed that said when they were both gone, it was going to go to the grandson. The son on title was going to go to his son. They didn't want to do a trust. It was just simpler, the father had some health issues. So it was just a matter of if something happens, we want to make sure that it gets to the grandson. Um, After the son passed away, he did end up passing from his health issues. Grandma with one of her other kids did a different transfer on death deed. And that's how transfer on death deeds work. It's you can do one, you can revoke it,
Mm,
you can just say, never mind, I changed my mind. You can do a subsequent transfer on death deed, and it's going to be the most recent one is what's going to control. So mom and son are on title. They do this transfer on death deed. Son passes away. Mom still owns the property because transfer on death deed doesn't change anything about title during the lifetime of the owners. So mom is still on title. She decides, to change her mind, or in that case, they're arguing about, capacity issues and undue influence. But regardless, we've set up, if there had been a trust and maybe someone else's trustee, you have a little bit more protection against someone changing their mind
mm.
later, or being not changing their mind. I shouldn't say that because you can always change your mind, but being unduly influenced,
Right, right.
just one example of recent memory where the transfer on death deed didn't quite work out.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Katita and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by ToBA Financial. For Jason Katita, investment advisory services are offered through ToBA Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.